So thank you all for coming this morning for one of our very exciting attorney panel events.
How many of you have assisted your client in drafting provisions for the lease? Yeah, put your hands down quickly. It's probably the number one biggest item that we're seeing on the litigation side relative to leasing, and that is assisting clients, trying to do what you think is a good idea and helping them negotiate a lease term, and then having that come back because that's the lease term that's then in dispute, helping out effectively lawyering and helping them draft it. My first advice is if you give a client a lease, a form lease to look at, that is the extent of what you really should be doing with that lease. It's a legal document. It will be binding, and it's the language that we then will be negotiating. If you've played a role in that drafting of that provision that you then amend the lease, in all likelihood you will then get sucked into whatever dispute has between the landlord and tenant.
On page 4, a form that can be used for appointing a designated agent, the dual agency form, you've all seen it, it all says it's usually signed at the time that the listing is signed in some generic format. On the buyer side, if you're representing a buyer, you're probably having them sign that in a generic format too when you first engage with them. But when you have a specific property that the buyer is going to bid on, and it's a listing in your firm, you need to have them sign a specific designating that property, a specific dual agency form, and the seller also has to sign it. The key really with dual agency to protect yourself is to make sure that you're disclosing at the right time and that you actually have a conversation with your buyer or seller about what it is that they're consenting to.
Most of you know how a contract is formed. First off, there has to be at least two parties. So you could not have a contract with an entity, an LLC, that hasn't been formed yet. And there has to be some consideration, meaning someone has to give something up. That's typically money and the right to sell your property to someone else. And it must be in writing when it comes to real estate. So those are some immediate thresholds. Now, typically, and it doesn't have to be this way, but typically the seller's attorney prepares the contract. It's unexecuted, it gets delivered to the purchaser or the purchaser's attorney. The purchaser then signs it, presumably after there's been some discussion between the purchaser's and seller's attorney as to some tacitly agreed upon language. And the purchaser signs it, gives a down payment, sends it back to the seller's attorney. The sellers then sign, and it then goes back to the purchaser's attorney. It is not a contract until the purchaser's attorney actually receives it. So it's not a contract until the purchaser actually receives it. So if you're delivering the contract and it's sitting in the back of your car, don't make a stop along the way. Right? Get it there to where it needs to go. Now the other thing is that if there is a change, if the seller's attorney has made a change to the contract from the way it was delivered to the purchaser's attorney, then it needs to go back again. It needs to be ratified. So the purchaser has to agree upon that change, and the seller has to receive proof that they've agreed upon that change.
Is multiple bids and accepted offers and sort of this ethical concept of, well, what do we do? God bless us that we have multiple bids, right? We are all very happy. And I think if you're competitively listing and pricing your property, you may very well be in that situation, even in today's market. Let's put it that way. First part. So then you now succeeded and you have a listing with a great price and you have multiple bids. So how are you assessing that? You have no one transaction is alike. And so I always say, well, you have to look at it as apples to apples and oranges to oranges, right? So is this a cash deal? These are all things that everybody knows, but you sometimes forget when you're assessing, the numbers appear to be greater on one transaction, and yet the risk is greater. And so what's the tolerance for that risk? At the end of the day, what's your goal? Your goal is to best serve your client, the seller, to get the deal done at the end of the day for the seller in the most expedient way that Rob discussed. So I think the other part of it is okay, so now you have the accepted offer and another offer comes in that's higher. Now what do I do? Well, you have not signed, your seller hasn't signed and delivered the contract, or it's not sitting in the back of the car, or whatever the case may be. So you have a fiduciary obligation to convey every offer. Even if it were less, whatever the case may be, you have to convey that offer.
Great, thank you so much, guys. Thank you. That was very informative.